Okay, great. Okay, well, welcome back, everybody, to the second session of this Reparations Conference. My name is Anna Bryson. I'm from QUB Law. I'm going to chair this session on reparations for armed conflict. So we have 4 speakers in this session. I'll introduce them in turn: Kevin Hearty, Ruben Carranza, Kieran McEvoy and Stephen Oola. They've been asked to speak for 10 minutes each, although I understand Kevin Hearty has negotiated a special dispensation of 12.5 minutes, so we'll try and hold you to that, Kevin.
At least 12.5.
But yes, we'll take the Kevin and then Ruben and then Kieran and then Stephen. So Kevin is a colleague of mine. He's a lecturer in the School of Social Sciences, Education and Social Work at Queen's. He's written extensively on victims and victimhood, ex-combatants and informers, and he was formerly the postdoctoral fellow on this reparations project, so has had a key role to play in developing the guidelines and other outputs. So for 12.5 minutes, Kevin, over to you.
Perfect. Good morning, everyone, or afternoon, as it probably is now. I'd like to begin by thanking you for giving me the opportunity to make a very small contribution to today's important discussion. Today I will be discussing some preliminary research undertaken with Luke Moffat and Daniela Suarez Vargas on compensation for conflict-related bereavement in Northern Ireland. While the issue of compensation has been in the headlines recently, our analysis of dozens of cases, particularly the earlier ones, points to a statutory compensation system that not only lacked any semblance of consistency, but was utterly devoid of compassion too. And given the natural sensitivities around the subject, today I will be relying on cases that have been discussed in existing studies, open access sources and archived accounts. So it's necessary to acknowledge some important caveats before I begin. Firstly, as debates around the pensions for the severely injured and the earlier Eames-Bradley proposals have shown, compensation can regrettably become enmeshed in politically toxic debates about victimhood. Different perspectives on this have been well rehearsed elsewhere, and I see little need to or value in revisiting such a divisive issue today. Secondly, critically examine compensation for conflict-related bereavement is not to naively suggest that it is a panacea, and I feel little need to point out to those among us today with lived experience that bereavement creates a range of complex needs for victims and survivors, not all of which can or indeed should be addressed through monetary compensation. Finally, we must frankly acknowledge that no amount of money can ever truly reflect the enormity of the loss caused by conflict-related bereavement, and it is worth recounting here the words of one victim's son following a recent award. Today's settlement doesn't bring back our loved ones. The hurt, the loss is felt every day. Today and every day, we think of our family members who can't be with us. So as political violence worsened in the north of Ireland, the human and financial costs began to escalate. Official figures indicate that by as early as August 1972, 17.4 million had been paid out to various victims, with a further 15 million being paid out for property damage. By the time of the Good Friday Agreement, £26 million had been paid out to those bereaved by the conflict. Yet the anomaly is that despite these headline figures, many families received little for their loss. Some victims rejected compensation offers as blood money, others were not in a position to reject it despite their misgivings. For some families, bringing a civil case was about getting the truth about rather than money for their loved one's death, and in other cases still, it was suspected that compensation payments were being used to avoid criminal justice accountability for state violence. So compensation for conflict-related bereavement was initially addressed under the terms of the Criminal Injuries to Persons Compensation Act, Northern Ireland 1968. And under this provision, anyone who was injured as a result of what was classified as a criminal act could seek compensation upon application to the county court. By 1976, approximately 90% of claims brought under this provision were conflict-related. However, judicial discretion led to inconsistencies in the amounts awarded to different families, with a multitude of factors ranging from gender to access to legal representation proven relevant here. Increased financial pressures and other factors led to reform of the system. So accordingly, compensation for injuries sustained on or after the 9th of August 1977 would be dealt with under the Criminal Injuries Compensation NI Order 1977. This established a new administrative scheme overseen by civil servants, though notably the Secretary of State retained the discretionary power to reduce or refuse compensation where a victim had been engaged in illegal activity or did not fully cooperate with the police to identify and apprehend their assailant. and in a context where some sections of society had little to no confidence in the criminal justice system and police force, and where the exact circumstances surrounding certain deaths were deeply contested, this was obviously problematic. So in terms of major factors that influence compensation, one of the most significant was the income of the deceased, which is, of course, naturally tied to other factors like employment status, gender, and age. And in the context of a conflict where most of those killed were working class people from socio-economically deprived areas, basing compensation on income rather than need naturally placed a significant number of families at a distinct disadvantage. And a cursory glimpse at some of the earliest cases exposes the inequality and inconsistency in the system. For example, the widow of a leading cancer specialist killed in a 1975 IRA bomb in London was awarded £40,000 in compensation. And this payment, along with the proceeds of the sale of the family home, allowed her to secure her children's financial future. Yet she would still protest that. You cannot win in this situation. You are grateful for what you receive, but people could quite easily say you were greedy if you said it was not very much. I suppose we are lucky that the state gives us anything. Compared with some of the awards for accidents, it might be very low. By contrast, families whose loved ones were employed in poorly paid manual labour jobs, or who were temporarily laid off work, or who were in receipt of other states' benefits, received far less generosity. For example, the widow of a man killed by the British Army in 1971 was awarded £350 compensation for herself and her 9 children. And most problematically, the case heard prior to this had seen the owner of a prized greyhound being awarded £700. Reflecting on this, the victim's daughter later asked, "Where in any land is the price of a dog more important than my daddy?" In a similarly disturbing case, a widowed mother of 12 was informed that because her husband was on sick benefit when he was killed, she was now actually £1 a week better off on a state widow's pension. In other cases, compensation payments offset benefits payments that victims' families were otherwise entitled to. And an instructive example here being the parents of a teenage girl killed in 1981 having their supplementary benefit payments stopped by the DHSS. Gender was also a significant factor in terms of how families struggled to cope with financial hardship following bereavement, and in terms of how the lives of women were undervalued by the compensatory system. One victim whose mother was awarded £12,000 following the killing of their father captured the reality of this. The whole thing took a toll on her. That money that she got was ludicrous. Life was very difficult for us growing up. We had no money. We lived for my mother's widow's pension coming in every week, and we didn't have a fridge until I was 11 years old. Rarely, however, was such a reality acknowledged within the compensatory system. In one particularly insensitive and nakedly sexist example, a young widow was told by the judge that she was a young, attractive woman who could marry again. Echoing the shortcomings of basing the system on income rather than need, unpaid work within the family home was often looked on much less favourably than paid employment, which naturally placed the families of women victims at a disadvantage. And some of the payments that we have come across for women victims go as low as £84 and £149. Although the NIO made some attempt to address the gender gap in 1975, the following remarks from the husband of an Oola bomb victim suggest that gender imbalance still persisted. Because she was a housewife, she had no monetary value, as opposed to someone who worked 80 hours a week. She looked after her children. She was their mother. If she had been a solicitor or a teacher, they would have given money out from she was 39 years old until she was 65 years old for what she would have earned. But because she was a housewife, she was treated like garbage. At the end of the day, it is not about money, it is about fairness for all. Likewise, the families of children killed during the conflict were also disadvantaged by a system that premised itself on income over need. And one case relating to the deaths of 3 children and the injury of their mother when an IRA getaway vehicle veered out of control under security force gunfire in 1976 is particularly instructive. Initially, the family had a claim for an unspecified sum for the loss of their children refused. They were informed at this time that they were only entitled to funeral expenses. A subsequent compensation offer of $3,500 from the NIO in 1977 was rejected by the family, with their mother commenting that, "I am utterly disgusted with the offer and I am obviously going to fight it. I have broken up my home, lost my children, and they have the cheek to offer me £3,500. And it should be noted here that in other cases, awards as low as £56 have been recorded for child victims. There's a tension here between sufficiently recognising the human aspect that the loss of a child in such circumstances can be particularly devastating with, from the bureaucratic perspective at least, some acceptance that they were not economically active, nor had they dependents at the time of their deaths. Further friction is also evident in how the cold and detached bureaucratic way of seeing the child victim as they were at the time of their death fails to correspond with the tendency of families to see the unmet potential inherent in the child. Perhaps this is best captured in the following remarks of the brother of a young girl who was killed in a bomb attack in the 1990s. My mum got around £5,000 when my sister died. They didn't know what my sister would have grown up to be. Compensation should be the exact same for everyone. My sister was a young girl. She had her whole life in front of her. Who knows what she would have grown up to be? Access to legal representation was also a significant factor, especially for victims killed by the state. Commentary at the time, and indeed more recent archival work by NGOs like the Pat Finucane Centre, suggests that there was a deliberate policy of hardballing victims. And this involved the Crown Solicitor denying any wrongdoing right up until the courtroom door, before finally trying to settle claims before they reached the courtroom floor. The stark choice in this situation was to either accept the derisory offer or reject it, with a view to renegotiate with the NIO or taking the case to the county court for adjudication. In many cases, low offers were accepted because victims and survivors were unaware of their rights, were in dire financial straits, and did not have access to the necessary legal representation advising them against acceptance. For others, acceptance meant avoiding the added trauma of a long drawn-out legal process. As Kenneth Bloomfield noted, a critical moment comes when an applicant has to decide whether to accept an offer made to him or her. Some felt that they faced an invidious choice between acceptance of an unsatisfactory award and the consequences of further delay, perhaps leading to a court appearance and the prospect of adversarial cross-examination. Those who could afford legal advice were better placed to contest initial offers, often resulting in a significantly improved offer. The disparity between initial offers and revised offers made after legal advice was notable, as can be seen in the case of a man who was injured in an attack by the Shankill Butchers in the 1970s. Having rejected an initial offer of £750, he was subsequently awarded £5,000 a year later. To conclude then, in light of our discussions today about devising reparation programmes and processes that are truly victim-centric and premised on the buy-in and input from victims and survivors, what can we say about the compensatory system for conflict-related bereavement in the North? Well, it would seem fairly obvious to me at least that a system that values the life of a greyhound as twice that of a working-class father, or that sees remarriage as a solution for the financial difficulties faced by young widows, is not a model of best practice, and that's probably putting it mildly. Instead, it represents an invidious system that set victim against victim by creating material hierarchies of worth among the bereaved, that compounded emotional trauma by failing to alleviate financial hardship, and that allowed sexism, ageism, classism, and able-bodiedism to ensure that life became not only figuratively but also literally cheap during the conflict. Recent significant payouts in high-profile cases must not allow our discussion around this issue to lazily slip into knee-jerk reaction that further exacerbates division among victims and survivors. Instead, we should use these recent cases to engage in a more nuanced re-examination of the fundamental problems that rendered the statutory compensation system unfit for purpose across the board. Thank you.
Thank you very much, Kevin, for sticking very well to time. So our next speaker is Ruben Carranza. Ruben leads work on reparations at the International Centre for Transitional Justice. He's an expert on the intersection of transitional justice and accountability for corruption and economic crimes, particularly in the Global South. He's worked with numerous truth commissions and commissions of inquiry around the world and has published widely on the basis of that research. And drawing on that experience, Ruben is going to talk to us now about some of the implementation challenges he has identified along the way. Thank you.
Thank you, Anna, and good morning to everyone, including those on Zoom. I hope this will be shorter than what you need. Let me begin by saying that as a non-academic, I often have I would have a different PowerPoint, that's why I'm not using one now. And it's often designed to discuss reparations with victims' organizations, civil society groups in the Global South mostly, and therefore often presented in a way that's specific to the context. In many of the contexts I work with, when we do workshops, when we do meetings on transitional justice and on reparations, when you ask people what they want to hear, nobody really comes forward and says, I want transitional justice. Sometimes they will say, I want justice, but that's their conception of justice, not our conception of justice. When you ask them what they want, they respond with what they need. And I've had debates within ICTJ and outside ICTJ on this question of need versus want. Many of you are lawyers, and I think many of you will understand the distinctions between human rights as rights that can be enforced and needs. The question of are needs rights-based? And that brings me often into discussing economic and social rights and reparations for violations of economic and social rights. That's a different discussion slightly, but I want to mention it. When at the beginning, I think Luke made reference to the vernacular of reparations, and that's another point I often have to deal with in the countries where we work with. Nepal, as James has partly discussed, Nepal is one country where I worked for several years, and in Nepal, Palipuran, that was the word used in Nepali, implies not just hierarchy and caste, but also particularly class. Class as a more universal concept than caste systems. So that when, in my very first visit to Nepal, well, second visit to Nepal actually, many years ago, I sat down on the ground in a schoolyard in a rural area with victims of the 10-year conflict in Nepal. And that was where I first heard the phrase used by Maoist activists in Nepal, but then later on adopted by victims in Nepal. What do you need? The answer is in Nepali, gas, bas, kapas. It rhymes because it's used by Maoist activists. So you have to be able to chant it in the streets. But it also was adopted by victims because it reflects what they need: food, shelter, clothing. Gas, bas, kapas. So why would you talk about human rights? Why would you talk about the meaning of reparations? When you ask them, they have an answer. So that, not only does that complicate a discussion on implementing reparations, but it brings up larger philosophical questions of should we design Belfast guidelines, for example, that touches on this question of ideology. What are the assumptions when we talk about reparations and transitional justice, or do we try to gradually adapt to changing the discourse so that it shifts from law-based mostly to something that reflects the context? So there are three things I'd like to talk about very quickly based on the publication, the Belfast Guidelines, and partly the non-state actors book that you came out with. The first question is the guidelines, and I think properly, talk about reparations being transformative, that they should be transformative. I think that's an important break from Theo van Boven's guidelines, because many years ago, I remember sitting in a meeting in Amsterdam, and I asked Theo van Boven whether in writing his guidelines, talking about human rights and violations and reparations, I asked him whether, when he was writing it, whether he thought economic and social rights are part of the human rights he was referring to, and he said yes. And I said, but how come it doesn't seem to be reflected in your guidelines? And, of course, it was only a 2-hour meeting, so there was no time for him to answer that. But I'm glad that the Belfast Guidelines talks about transformation, and I know that I've had colleagues talk about this as well. I'm often puzzled by the fact that when asked for examples of what might constitute reparations that are transformative, the usual example is Morocco and the changes in the law on inheritance so that women inherit equally as men in terms of reparations. And when you ask for more examples, there are very few or maybe none. And I'm sure, I don't know whether Julie is here. Julie Guillermo, she was our coordinator in Morocco. So Julie and I have had this long discussion over whether that is in fact transformative or not. But a larger question about this, and I'll leave it at that, because I only have maybe 5 minutes left. When we say transformative reparations and then we also acknowledge implementation challenges, do we assume that both can be done simultaneously? Do we assume that we can implement reparations given the findings that very few reparations programs have in fact been implemented, whether they were recommended by truth commissions, ordered by human rights courts, or as part of judgments in criminal cases? Do we think that reparations can both be transformative and can also be implemented at the same time? The second point I would raise is post-conflict reparations and the concept of post-conflict. What do we mean by post-conflict? When we say that, do we assume that all conflicts are equal? In the real world, a lot of the work we are doing on Syria, for example, is because there is funding for Syria work on reparations. That's why I talk about housing in post-conflict Syria to Syrians. And then some of my non-ICTJ colleagues talk about Ukraine and freezing the assets of Russians so that they can fund reparations for people in Ukraine. But we don't hear that. We don't hear housing talk about Yemen. We don't hear assets being frozen. Well, they are frozen for Afghanistan, but by the US so that the Taliban can use them. So not all conflicts are treated equally. And I think when we talk about post-conflict reparations, it's important for us, and us here means me and everyone else in the room, to address the elephant, that post-conflict reparations must address all conflicts and not just those conflicts that donors want to address. The third point, and again, this was partly triggered by the mention of civic trust. And I did not get this when I was reading the Belfast Guidelines. I only heard it, Luke, this morning. That reference to civic trust or trust in the state not improving even with the delivery of reparations. I think that's a very important point, again, not from an academic perspective, which is not the perspective I have, but from a practical perspective. I know this is recorded and on the record, but I should say it anyway. The idea of civic trust was developed by my former colleague, Pablo de Grief, the former UN Special Rapporteur on Transitional Justice. I've always disagreed with the concept of civic trust. Not the concept, perhaps, but the idea that it is a goal of reparations. First of all, what is civic trust? I mean, did we ever talk about that years before he talked about it? I'm not sure. But even if we did, what is it and why should it be a goal? I'm not clear at all that the idea of giving victims, especially the poorest victims, what they need is because we want them to trust in the state. Why should they trust in the state? Why should developing trust in the state be a goal of transitional justice? What is the inherent value of trusting the state? I don't know, but to me, I think it's important to have the empirical basis to say people don't necessarily trust in the state when you give them reparations. A last and final point in terms of, again, implementation challenges. When I was working in the Philippines, I was going after the assets of the Marcos family, and we were able to recover $680 million from their Swiss bank assets. And just before I left that work, I drafted a bill on reparations that would give $200 million out of the 680 to fund the reparations program. It took 10 years for that bill to become a law. It took another 2 years for that law to be implemented. And then Ferdinand Marcos Jr. is now president of the Philippines. So it's important to implement reparations, but it's important to implement it quickly, and it's important to implement it in a way that matches larger goals of anticipating the future. You have to anticipate the future and not just deal with the past when you implement reparations. There are other anticipatory issues that I will just drop as concepts and can be developed if there are questions. Climate change is one issue to anticipate. I've done work in the Solomon Islands. ICTJ has been asked to do work in the Seychelles, in the Maldives. These are islands that are sinking. And in the Solomon Islands, one recommendation of the Truth Commission was to give people who fought in their own, they call it the tensions, in the same way you call it the troubles here. People fought over land, and one of the most valuable areas of land in the Solomon Islands are the coastal areas, because that's where fishing and shipping can happen. But those coastal areas are now being eaten by the sea. But they are recommendations for reparations made 20 years ago. So how do you deal with that? So now we have to anticipate these questions of land and resources as material forms of reparation. Social media is another aspect of reparations that I've always thought important to deal with, especially in relation to disinformation, especially in relation to how victims are seen and are labeled. And social media has become part of that machine of disinformation and labeling that we should deal with. So let me end with this almost random set of issues, but I'll be happy to answer your questions.
Thank you very much, Ruben. It wasn't random at all. That was fascinating insights that you shared with us. So our next speaker in this panel then is Kieran McEvoy. Kieran is a Professor of Law and Transitional Justice at the QUB Law School and a Senior Fellow at the Senator George Mitchell Institute for Global Peace, Security and Justice. Kieran is a Fellow of the British Academy and a member of the Royal Irish Academy. He has researched in over a dozen conflicted or transitional societies around the world and has published widely on the basis of his research findings. Perhaps most pertinently for our purposes, he was a senior co-investigator on this project. And the topic that Kieran is going to speak to now concerns non-state armed groups and reparations. So over to you, Kieran.
Thanks very much, Anna. Before I get into the meat of the paper, I just want to take a second to pay a tribute to Luke in particular on this project. So as he said earlier, he started out his career working as a postdoc on a project that I was running. Then he became my boss on this project, and he was a joy to work with, actually. Like, this is a big beast of a project, as you can see, and he managed it all with great grace and aplomb. So I just wanted to put that on the record while we're here. I'm going to give you a very brief 10-minute summary of a complicated paper that Luke, Cheryl Lawler, and myself were involved in writing as a result of the fieldwork from this project. The paper itself is in a journal called the Journal of Human Rights Practice. Luke and Cheryl and I edited a special issue on that. If anybody's got a particular interest in it, just drop us an email and we'll send you the full PDF of this. So you're just going to get a feel for it. In the paper, what we're doing is, so we're focusing on non-state actors, not just states. In effect, what we're saying is that because reparations people tend to see reparations through a state-centric lens, you know, the legal and financial responsibilities and other responsibilities in terms of human rights compliance that states have, non-state actors who've been involved in violence shouldn't get off the hook. Basically, they have responsibilities as well. And so part of what we were doing in the paper was trying to find creative ways of seeing how we could help and facilitate that. I think as Peter said in the last session, victims don't speak with one voice, and victims didn't speak with one voice across the 6 jurisdictions that we conducted our research. And some victims will quite understandably say, I want nothing to do with reparations from non-state armed groups. I'm not interested in it. That's fine. That's their right. Other victims take a different view, and there's a spectrum, obviously, between those two poles. And so we were kind of in the fieldwork. We were exploring that spectrum. You've heard already the sites that we conducted the fieldwork in: Colombia, Guatemala, Nepal, Northern Ireland, Peru, and Uganda. For this particular paper, we were drawing on interviews with 29 ex-combatants from a very diverse set of groups across the sites and 93 victims of violence. In the paper, we draw on restorative justice. For those of you who don't know, restorative justice is an approach to crime or social harm that focuses on restoration, on the restoration of relations rather than simply on retribution. And in this context, obviously, you're talking about a restoration of relations between victims, perpetrators, and communities. And I suppose we were influenced by I personally had been heavily involved in restorative justice initiatives here to find an alternative to punishment violence, where ex-combatants from loyalist and Republican communities were involved in trying to challenge cultures of violence, particularly towards alleged antisocial offenders. And it was an element, a nasty, particularly horrible aspect of our conflict, where people were subject to these vigilante violence. And anyway, restorative justice emerged as community-based restorative justice emerged as an alternative to that. So it provides a framework for moving beyond punishment, moving beyond retribution. It provides a framework for non-state actors to take responsibility and attempt at least to repair the damage. And as I'll talk about it in a moment, it's also a process by which rehumanization can occur, both of victims and perpetrators. In the paper, we engage a lot in notions of what are victims' needs, and needless to say, we asked all of the victims we interviewed how they determined their needs, what were those needs. In terms of this paper, what we're looking at is how can the non-state armed groups then step into the breach to deal with those needs that were addressed by victims. So in some instances, people talked about non-state armed groups or individual members of non-state armed groups taking responsibility. Sometimes it's owning up. Sometimes non-state armed groups will have lied about whether or not they were responsible for a particular atrocity. So sometimes it's that, it's taking responsibility for it. Contributing to processes of truth recovery. And so in some of the sites that we were examining, you're talking about a formal truth process, a truth commission, and how do non-state armed groups engage with that. In other instances, you're talking about more grassroots civil society type engagement processes, where you have a structure around which non-state armed groups may be engaging, perhaps via an intermediary, with victims to provide truth about what happened to their loved ones. In other instances, it's about the recovery of remains. People have been disappeared by non-state armed groups. And in others, it's about apologising, statements of apology or acknowledgement around all of that. And the way we frame it in the paper as well is that in some ways reparations from non-state armed groups can be seen as a kind of practical and a symbolic engagement by such groups in efforts to make sure it doesn't happen again. It's about transforming cultures and putting in place a practical framework around non-recurrence, which, as everyone knows, is one of the key pillars of transitional justice. So this notion of rehumanization, as I say, this is a thread that we put through the paper. One of the things that comes out very strongly from our research and from other research is that the process of human beings being engaged in violence requires a dehumanization of the other. In order to be able to rationalize or indeed to live with yourself for engaging in visiting violence upon another human being, there are different ways in which you dehumanize the other. So, for example, the notion of the legitimate target is one way of saying this is not a human being, this is a person wearing a uniform, or this is a person from an enemy community. And that's kind of hardwired into a lot of armed group ideology. I've got very interested now in the kind of literature that's around how armed groups think, basically. How do they create values, mores, and working practices? And one of the key bits of that is this idea of legitimate violence. And legitimating violence requires a dehumanization. So part of what we talk about in this paper is about reparations as a way of breaking through that. In the psychology literature, they call this techniques of neutralization, ways in which we neutralize our own moral or our own responsibility to the humanity of others is a technique of neutralization. So how can we frame reparations in ways that challenge these techniques of neutralization? Participation in the paper, we talk about the ways in which participation by non-state armed groups and ex-combatants can promote versions of accountability, and there's different kinds of accountability, thick and thin versions of accountability, but that they can help. Our friend and colleague Shad Maruna he's talking about, in non-political context, he's talking about ordinary criminals, but the ways in which ordinary criminals, people who've been through the criminal justice system, can make good on the harms that they've inflicted. And so we kind of tweak and adapt Shad's work on making good, which is very famous for criminologists, and see what's useful. He comes from that kind of social psychology background, and how that can be used and adapted in our efforts to move from conflict. And also, we argue around reparations can represent ways of destigmatizing in some instances perpetrators, destigmatizing victims, challenging cultures of violence and fear, which are often, just because a conflict has come to an end, it doesn't mean that you've dealt with issues of fear and intimidation in communities and all of that. So practical engagement by former combatants in reparative work can help to challenge all of that. Restorative justice for us is part of the vision thing. Basically, it's a way in which capturing some of the complex moral, political, and ideological processes that are involved in moving away from violence. We've got some great quotes. I'm not reading them out to you because I've only got 10 minutes. But threaded throughout the paper, there's some really lovely, lively quotes from across all 6 of the sites to highlight some of these broader theoretical points. So if this sounds a bit dry, the quotes kind of liven it up whenever you're actually reading it, you know. The practical aspects of this, so for example, in the Colombian context, so FARC and other non-state armed groups were involved in laying mines, lots of mines. And one of the ways in which they tried to protect the territory that they were controlling in the jungle was by putting down hundreds of thousands of mines. They're the people who know where the mines are. And so part of the process of demining in Colombia is basically former FARC combatants working with the military, their former enemies, in practical efforts at demining. And obviously it carries a lot of, it's important work, it needs to be done. They're the people who can do it because they know where they are. But there's really interesting relationship aspects happening there in terms of relations between FARC and the military. The other thing that's happening in the Colombian context is that as part of the demobilization process of FARC moving out of violence, their security, the former FARC combatants, is being protected by the military. They're, you know, so in some instances they're in demobilization villages. They're still at risk. The former combatants are at risk of being attacked by paramilitaries or others who they've hurt. And so there's interesting things happening in terms of relationships between former FARC combatants and the Colombian state military. And then the demining is a practical example of that. People from Northern Ireland will be aware of the disappeared process here. So people who were murdered and disappeared by the IRA. A framework was created between the British and Irish governments whereby information could be provided through a commission to help return those bodies, knowing that prosecutions would not arise from that. It's been a very successful transitional justice model. There are still a number of bodies outstanding, but it's a complex and interesting piece of work. And the only reason that it worked is because relationships of trust were built up between the non-state armed groups, in particular the IRA, and in one case the INLA, and the Commission themselves. The Commission is headed by a former British police officer, and so for him and his colleagues to create relationships of trust between a non-state armed group and his Commission in terms of it's a really interesting process. But anyway, again, the non-state armed groups are the people who know where the bodies are. They're the only ones who can do this form of reparations. Now, this is, I'm coming to the end here. So on a separate project, Anna and I have been involved in working for a number of years now on the issue of apologies. Apologies are often seen as one of the bits, one of the sub-bits of reparations work. And so in that work, and it dovetails obviously with this project, we have been looking at what makes for an effective apology. I need to say that apologies are not a substitute or an alternative to truth or justice or reparation. They're part of a bigger package. You know, so saying sorry as the only thing is not enough. But in that process, this definition has been adopted by the United Nations. We did a paper for them in 2019. And so this is what a proper apology might look like in a post-conflict context where the wrong is named, where it's been deliberately or negligently inflicted, where there has been a truthful admission of individual or organization or collective responsibility. So the armed group, for example, in this case, it also applies to states as well, obviously, accepts responsibility and doesn't try to use words that minimize or exculpate their involvement, that it involves a statement of remorse or regret related to those acts, that there's a credible promise of non-recurrence, that it's linked often to appropriate compensation or other reparations, that very importantly, that it's underpinned by effective consultation with apologizing constituency. We were very interested in the ways in which, for example, the Bloody Sunday apology included a discussion with relatives of those killed in Bloody Sunday, and that's a good practice. Obviously, if you're going to engage in an apology, you need to be talking to the people to whom the apology is addressed. You need to engage them in the conversation, because if you don't get it right, then you don't often get a second bite of the cherry with this. So you have to actually talk to those. The apology must be made without reservation, qualification, or justification. It must be delivered by a person who has credibility in delivering that apology. So, for example, in our context, one of the things we've been exploring is whether apologies coming from republicanism can senior Sinn Féin members who were not involved in the IRA, can they credibly apologise, or does it need to be people who actually were involved in the IRA? We're going to have a discussion about that, and it needs to be delivered in ways that are respectful, dignified, and so forth. So, to conclude, ex-combatants can and in our view should be involved in delivering reparations, but it depends on the willingness and capacity of the individual group and whether or not they can do it. Stress again, victims have an absolute right to say, I don't want to engage with such a process. So that's taken as given. These processes are complementary. They are not an alternative to truth and to justice and so forth. They're complementary to those processes. As I've said, sometimes it's the armed groups are the only people who can make practical reparations. You know, the only ones who know where the mines are, the only ones who know where disappeared, the only ones who can provide truth recovery to victims. In the paper, we talk about this as providing a moral pathway, basically, for ex-combatants to be involved in a way of restoring them back into some kind of relationship with the community. And our final point is that just broadening the notion, historically within the academic literature certainly, reparations was quite state-centric and quite legalistic. A lot of stuff about international law, and so in our view, the non-state actors also have responsibilities, and this is us attempting to try to help them to step up. Okay, thank you very much.
Thanks very much, Kieran. Look, Stephen's not coming in online. Sure, he's not. No, this is leaving us with the 15-minute. Oh, he is. Sorry, I wasn't sure if he'd. Okay. Well, sorry. So, let me introduce Stephen then before you see from him online. So, Stephen is a senior advisor in legal and constitutional affairs at the Joint Monitoring and Evaluation Commission, overseeing the implementation of the agreement on the resolution of the conflict in the Republic of South Sudan. Stephen is also the co-founder and director of the Amani Institute in Uganda and an advocate in the High Court of Uganda. He's worked as the transitional justice lawyer at the Refugee Law Project in Kampala. And again, drawing on that wide and broad experience, Stephen is going to talk to us now on the challenges of reparations in post-conflict societies.
Thank you, Anne. Thank you, Kevin, Ruben, Kieran, and all the previous speakers. I'm happy to join you today from Juba, South Sudan. I hope the audio is okay. I can hear some echo. Yes, my name is Stephen Oola, and I want to start by congratulating Dr. Luke and the team there for bringing this project to a successful end. I've been part of this project from the beginning, and I know how hard you have all worked to get us to this point. I want to add my reflections on some of the very interesting insights that I've listened to since morning by drawing you specifically to the context in northern Uganda, where I come from, and some of the learnings that we
First time I've ever seen a tech breakdown. That's never happened before.
Is he in Kampala? He's in Kampala.
Do you think, do you want to give him a minute to see if he can get back online, or do you want to go to questions and
let me remove the video so that the network is a little better. Is that okay?
That seems fine now, Stephen, yes.
Okay, thank you. Yes, so I wanted to draw you all to northern Uganda, a context I'm more familiar with, where I come from and where we did a bit of work with Luke in respect to this project. Northern Uganda, for those who know, suffered brutal over 2 decades armed conflict, which we started in 1986 up to until 2007. Practically, the conflict is still going on as the parties of the government of Uganda and the Lord's Resistance Army are still at war. What has shifted is the theater of operation. As Kevin asked, as Ruben asked, what do we mean by post-conflict? So even though we refer to Northern Uganda as a post-conflict situation, the war itself continues, but this time in parts of the Democratic Republic of Congo and Central African Republic. What is important is that the conflict left scores of victims across Northern Uganda, and across the 2 decades, it attracted a number of justice actors, including the International Criminal Court and nationally what we call the International Crimes Division, and a number of international organizations. Despite the interventions by these mechanisms, both locally and nationally and internationally, I'll add, meaningful justice remains a mirage for many of the victims. Reparations in particular, which many of the people in Northern Uganda equate to justice, remains a far cry. Now, in 2020, myself and Dr. Luke conducted a study on perceptions of reparations and challenges in implementing reparation programs in Northern Uganda and Uganda generally. We interviewed a number of victims and a wide range of stakeholders. Some of the people we interviewed were directly affected by the conflict, others were indirectly affected, and others were basically those who occupied government positions responsible for devising responses to post-conflict issues. Now, some of the interviewees, as I said, were directly engaged in transitional justice efforts. Others were not even interested, but the majority felt that all this discussion around reparations was hopeless. So if you read our report, which we entitled Chulpibal is the local translation of paying for wrongs or righting wrongs, reparations for the Northern Uganda conflict. We detailed the compounding effects of armed conflict, how it impacts individual, family, community across different levels, and how this impact continues to reverberate over time and through subsequent generations. And this is more pronounced in Northern Uganda, as I say, because the conflict itself now spans over a generation. And you have those who speak in terms of post-conflict, but if you meet those whose children were abducted and have never returned, they will talk about the unending conflict. The report further highlights some very interesting nuances on how ordinary people, victims and perpetrators alike, perceived of reparations, both as a discourse and as the practice which is ongoing in the country, and to what extent these programs resonate with their own senses of justice. Within the next 8 minutes, I want to basically reflect on the 6 key challenges that are identified in the report. The first is the question of stigma. Now, I heard Kieran talking about how reparation would help address stigma. But one of the biggest challenge to reparation program is the stigma itself, especially for ex-combatants, those who were abducted and returned among communities. Some of them who benefited from even basic reinsertion packages, not even reintegration. There were some minimum support given to some of these ex-combatants to return to their communities, to start their life. And these were deemed to be further by, especially those who did not benefit, to be like blood money. They are basically being compensated, and yet others perceive them as both victims, others perceive them as perpetrators. There are also peculiar challenges for those who have suffered sexual and gender-based violence, including those who returned with children from captivities, those who had been raped. And many of them are what you described earlier on as the silent victims, as opposed to those who come out and can speak for themselves. And the reason they don't want to come out is because of the stigma associated with their experiences. The second major challenge, which is pronounced in northern Uganda, is what we call the delusion with criminal trials or court-based reparations. There's a lot of fascination about prospects of reparation coming from the International Crimes Division and the International Criminal Court, which apparently is the focus of many international actors and even the state, with false promises being made to the victims to wait or to support a conviction at the court as the basis of reparations. As a result, everyone has been waiting for what will the ICC do for the myriad of victims who span across northern Uganda. What happened to the victims who are living with bullets in their bodies, those who are psychologically tortured, those whose children are still missing, and those who are not part of the victims before the court. So the challenge with this expectation is that to the ordinary people, they believe that the court will provide reparations for everyone. And you, as scholars, know that the reality is very different. And because of this, people have let the government or those at the national level responsible for reparation to go scot-free, because the court, unfortunately, has not done a good job to explain who and when any reparation, if any, would accrue and would benefit. The third challenge we identified is the denial of responsibility. In the case of the Ugandan state, the state holds out as the savior a lot of time. Together with the ICC, they corrupt, and people believe when they see the state working together with an international body like the ICC, that the state has been exonerated. And yet the contrary is what the victims know. Majority of the victims know that the real perpetrator in the conflict in northern Uganda is actually the state or the government, who did not only fail to protect the civilians and the children who were abducted, but also actively committed a lot of the atrocities that they are blamed for. So in this case, even when we see reparation programs or attempts by the state, it is often from the vantage point of we are helping you because you are victims of LRA. And this has seen many victims avoid even registering or coming forth to benefit from such programs. The fourth challenge, of course, which is, I think, cross-cutting, is the limited resources, especially in the global south, and the competing priorities. These are seen states and government avoid the mere mention of reparation program and instead opt for what they call recovery and post-conflict development programs, as opposed to efforts that would benefit individuals and repair them depending on their victimization. As a result, we have seen that many of the hardware components of development programs in northern Uganda, and you can mention a number of initiatives, the PRDP, which is probably on its fourth phase, has led to structural transformation in terms of infrastructure. But there's a huge gap between the population that are meant to benefit from this program and the development that have been brought. The fifth challenge is mistrust of the state itself and its intention to provide reparations. And as a result of this, a lot of the attempts by the government has been considered to be piecemeal and politicized in nature. It tends to come at the eve of political campaign and elections. And so to the majority of victims, these are considered to be a continuation of the war by other means. So basically, they see the state in its reparation efforts as strategizing to silence the victim, strategizing to win political backing, as opposed to acknowledging the rights to remedies of the victims who have suffered. Finally, are the structural challenges which are associated with reparation programming in most of post-conflict areas in Africa, which are institutionalized corruption. A lot of reparation attempts have been frustrated by the diversion of resources meant for victims. Even well-meaning programs which have been designed to target individual groups, and I can give a lot of examples in northern Uganda. People have been registered, those who lost their cattle, those whose land were occupied by soldiers. These are non-victims. And a lot of money has been allocated by parliament and channeled out by the state to benefit these people. But the first beneficiaries tends to be government bureaucrats, tends to be party loyalists, and those who are meant to deliver these packages to the victims. About 2 weeks ago, one of the prominent lawyers in northern Uganda, called Jude Ogig, who has been arrested for having swindled money meant for a family whose land were occupied by the LRA, by the NRA, the government. We did a similar study in South Sudan, and our findings reveals similar challenges actually exist in this particular context. And because of time, I will not go to that. But suffice to say that in general, the key challenges as we see in post-conflict situation, which hinders or impedes the implementation of effective reparation programs are cross-cutting and can be summarized as follows. One, the complex victim-perpetrator dilemma and the question of determining who is entitled to reparation from whom, when, why, and how. The contemporary nature of armed conflicts, especially civil wars, where the violence are intimate within communities, those who know each other, and are very widespread. The nature of atrocities that have been committed, with some of the harm clearly irreparable. Power play and the challenges of a victor rehabilitating the vanquished, well knowing that in the next electoral cycle, their hold on power will be challenged. As a result, we have a cyclical nature of violence and armed conflict, where today's victims are inevitable or inevitably tomorrow's perpetrators. I thank you very much.
Thanks very much, Stephen, and apologies for the glitches with the technology. I think we managed all right in the end, so thank you. We are coming right up against the lunch hour, but I think if you don't mind, I'll squeeze in time for just a couple of questions, if there are any from the floor. Yes, so James, go ahead.
Thanks everyone for your presentations. I have a brief question for Kieran and one for Ruben. I'm very interested in the use of restorative justice that you mentioned in the paper. And I was wondering what contribution you thought reparations for non-state armed groups could make to that restoration. Is it only going to be at a relational level between perpetrator and community, or perpetrator and victim? You know, mainstream TJ thinks about it as a state building or making contribution to state building. If it's not doing that, can it make a different contribution to broader social change, or is it at that relational level? And similarly for Ruben, I'm very interested, and I agree with the skepticism regarding civic trust, but if that's not the target for TJ as a vehicle of social change, are there alternative targets, or should we be more humble? Should we be suggesting that transitional justice can only make a difference at the victim, survivor, and perpetrator level, but not at that bigger structural level? Thanks.
Thank you. Do we have any other questions that I can gather up then, or? Okay, well, if people are still thinking, we might have time for one more if anybody does have a question, but since there isn't anybody with their hand up right now, I'll go ahead and ask you, Kieran, to address that question.
Sure. Thanks for the question, James. I think it's both. I think it's both practical and relational, and it will vary across contexts, and even probably vary across armed groups. Some armed groups have greater capacity to engage in this kind of work than others. As I said earlier, some victims may not want to engage, and that's their absolute right. So it's not a one-size-fits-all thing, but I think that practical engagement by, I mean, if you look at the paper, you'll see in some of the quotes, the practical engagement, for example, of FARC in efforts like demining, but other things, you know, like rebuilding roads, all kinds of interesting things. They're making a practical contribution to the reshaping of a society, but it also is speaking to something relational as well. It's a big picture issue around trying to transform relations in that context of society that was at war for 50 years. So it's both, but it's very context specific across different jurisdictions and across different armed groups and different types of victims. So it's a very qualified both.
Thanks, Kieran. Ruben, would you like to address the question on civic trust?
Sure. I shouldn't have raised that question because I'm not sure I have an answer. The reason I'm critical of the civic trust concept is that I said it earlier, it assumes that victims, citizens in general, should trust the state. I don't agree that that's something inherently good. But at the same time, when I raised the other question I raised, which is whether we can implement reparations while at the same time trying to make it transformative, it's not a rhetorical question. You can implement reparations. Sometimes you can introduce potentially transformative aspects to it, but you have to be very conscious of the minimum you have to implement, which is, in Nepal, for example, the interim relief program, they called it that. It was basically to give, for example, 2,000 rupees to widows of those who were killed, but then they were giving only less than that to wives of the disappeared. Now, is it transformative to say, let's equalize the amounts? It's reparations. I'm not sure. It might also be transformative in the sense that you force Nepali politicians to see that there is no distinction between widows and wives in that situation. But when we raise the question, both widows and wives do not inherit the land of their disappeared or dead husbands, then you bring, it's one notch higher. You transform more and more if you can. So that's possibly the more practical aspect to thinking about this. This concept of transformative reparations came up in the post-Arab Spring countries. And of course, it's easy to incorporate that in Truth Commission reports, in law journal articles. Nothing against law journal articles, but it's good to incorporate that. But how do you implement that when you just had a coup in Tunisia? So there, suddenly you just want reparations implemented, the minimum. Again, fund the Dignity Fund, see what you can do. So that's probably, the answer to that question.
Thank you. Certainly, yes. Come on, go on ahead.
Just wait for the mic.
Mark, do you want to?
I appreciate we're pressed for time, but it's in something you raised as part of your presentation, Ruben, where you talked about want, need, and human rights. And it's just from a practical perspective. I've recently commenced a discussion, and we're going to take potentially it further on a human rights basis in terms of the prosthetic that I was discussing earlier on, because I should have a right to access the most appropriate limb available, and it is available, so the National Health Service should do that. I shouldn't have to go and pay privately for it. Just a quick comment, yeah.
No. Thanks very much, Mark. Okay, well, yes, Luke has a question, so I think that might have to be our last question, just otherwise stomachs will be grumbling.
Sorry to hold everybody hostage from lunch. I suppose it's connecting to what Stephen said about reparations being almost weaponized as a political tool. How do you see, from Kevin, a great presentation of moving forward with talking about compensation for the bereaved here, when we know, 13 years ago it was turned into a whole media furore where you had people screaming and shouting the room down, and the whole transitional justice process got derailed because we were going to say we're going to treat everybody, and what Ruben said, but equally in the sense that we're going to give everybody the same amount of money and to recognise the harm. How do we sort of almost transform the politics here, which are still continuing the fight over the past? It's not an easy question, but...
Ruben, would you like to attempt?
The weaponization of
reparations sort of transform the politics that sort of stymie moving forward in reparations?
Yeah, I mean, there are many ways to answer that, but 2 points that I think would be useful for us here. First is, and I've always said this whenever I'm invited to lecture in a class on transitional justice, because law students easily get provoked, so it's good to provoke them. I always ask them, why is there an international criminal court, but not an international reparations court? And that raises many questions about how we prioritize and what we think is important. And if we make reparations important enough, that it's even more important than prosecutions. Really, more important than prosecutions because victims survive and perpetrators die. What do you do first? So I think that's one way to to force the question out into the open. But the second one is in relation to that point about transformative reparations. When the Tunisia Truth Commission wrote a memo to France and the World Bank, and they said, France, you have to apologize and contribute to funding reparations. The World Bank, you do the same, and also contribute to funding reparations. That was a very, very good step, except that they never held public hearings where they forced France. I already told them, you send a subpoena, a summons to the ambassador of France, and if he doesn't show up, go ahead with your hearing. The same thing, there's a World Bank regional office in Tunisia. You send a summons to them and force them to attend the hearing, and if they don't, I mean, there are many ways to force the question of reparations out into the open, including who should be responsible for reparations. And there are practical ways to do it, and I think with the guidelines and with your work, I think it's important to pull in those practical steps. It's important to say them aloud, because otherwise these truth commissioners and these reparations policymakers will think, it's not in the Belfast guidelines, so maybe it's not accepted, or maybe it's not the norm, and norms often kill revolutions, right? And that's what we should do. Let's disregard norms and be more radical.
And on that note, with a call to be more radical, I'll bring this. I have a question I'd love to ask you about civic distrust, and because it actually, I'm going to squeeze it and abuse my position as chair. Sorry, there I was, just bringing it to a nice close, and it's this issue of. I think it's really interesting, this issue of civic trust that you raised, because it resonates for me with the research you mentioned, Kieran, on apologies, and this issue that came up for us about whether or not you should expect anything in return for an apology. And what people said to us is, I'm owed an apology. Don't expect me to forgive. Don't expect me to increase my trust in the state as a result. And I think it resonates in some ways about that. And I even wondered on our template whether or not there should be another issue about it should be delivered with no expectation of on the part of it's because you're deserving of it according to transparent criteria. So I think there's something interesting there about the issue of trust that could be developed, but I will not abuse my position any further. We will adjourn this session now. Thank you so much to four speakers for 4 excellent presentations, and to those who contributed from the floor. So thank you very much.